if you're comfortable, it'll be made available once we've got through the technical bit of extracting it from the system.
Course.
You're comfortable with that?
I'm completely happy with that.
Right, good.
It would be strange for me not to be.
No, it would be a shame. It would be surprising. So, Louise, thank you very much for coming. We've all, just before the recording started, introduced ourselves to you and you to us. So I think you've got one or two opening thoughts to offer, and then we'll move to questioning whenever you've covered the ground you want to cover.
Lovely,
so over to you.
Well, first of all, thank you for inviting me. It's lovely to be here. And I want to make 4 points to kick off. So the first point is that the status quo is not sustainable. I think that what I see as a very considerable movement towards greater transparency is going to happen one way or the other in a more full way in the next couple of years. All the effort and the argument and the momentum right across society, not just around the family justice system, is in that direction now. I think we're moving now towards a change in the law that bans reporting of what goes on in family courts. And so in that context, the change towards greater transparency and openness in the family justice system can come with impetus and input from within the system itself, constructively meeting impetus and input from the outside. And that would give the system more opportunity to comment on changes and help shape them and build in thoughtful and well-informed safeguards and training and collaborations and so on. Or the family justice system, with its culture of resisting openness that has percolated through very many people working within it, like Brighton through a stick of rock, is going to find itself dragged kicking and screaming into a situation that it can influence very little, and it will lose even more public legitimacy in the process. 6 years on from having started to try to report on this aspect of our justice system, and observing over that time the vociferousness of the anger, the campaigning work, and I'm sorry to say the contempt with which many hold the family courts, and many academics and by MPs I talk to who roll their eyes before launching into expostulations of outrage on behalf of their constituents and detailed criticisms as well of what they think is going wrong. Well, I think my assessment is now that this is pretty much a situation of bend or break. My second point is that there is no point in fiddling around the edges. That was tried when journalists were allowed into family courts in 2009. It has proved almost entirely pointless. It could never have worked on its own, given the statutory restrictions that exist, and it hasn't. So there needs to be a change in the law, which I appreciate is not in the gift of this panel or even the president, but judges, together with other key players in the system, can, and I think must, deliver a radical change in the culture that prevails. There needs to be a sustained effort from the top down to secure that wholesale change in attitude in those working inside the system. And by that, I mean not just the lawyers and the judges, but local authorities and CAFCAS, who have all been protected from any really meaningful accountability for far too long, as human rights breaches highlighted in the very occasional published judgment demonstrate. So I can't remember if I told you this, but I have just set up a social enterprise called Scrutiny. Its strapline is "Scrutiny keeps the state honest and keeps citizens safe." And the organisation's vision is for citizens to feel secure that the state is enthusiastically open, willing to take responsibility for its mistakes and keen to learn from the harm it's caused. And I would say that enthusiastically open would be a very good starting place for the family justice system. My third point is that those working in the system need to appreciate and value properly, deeply, because they understand it matters, the value of open justice to democracy, and they need to practice it. One example among many I could give you. I have had my applications to be able to report on what goes on in family courts described as satellite litigation by 2 High Court judges now. One was David Bodie, who actually gave me very extensive permission to investigate and report on a case for The Guardian, and who I was very pleased to get the chance to thank when I met him at the Judicial College a couple of years later. And the other judge was Mr. Justice Williams very recently. The point I want to make by telling you that is this: a media application to be able to report on the detail of extraordinary powers exerted by the state that would otherwise happen in secret is not, in my view, and when looked at properly, satellite litigation. Citizens and the media's ability to effectively scrutinise the various arms of the state is fundamental. A healthy democracy demands it. When enormous state powers are wielded in secret, the expensive, time-consuming, onerous efforts by the press, or indeed by a party, to open up whatever's happened to public debate should be viewed as a valuable opportunity to be accountable for a system that normally operates in the shadows. Open justice is not an add-on. It is not satellite. It is critically important, most of all to the vulnerable people that the system exists to serve. Finally, fourth point. When I started off as a freelance journalist, which is just over 20 years ago now, and I got loads and loads of knockbacks, I had a quote blue tacked to my wall over my desk, and it was there for years. It's by Calvin Coolidge, who was an American politician and lawyer who was the 30th president of the United States from 1923 to 1929. You may know it, but it goes like this. Nothing in this world can take the place of persistence. Talent will not. Nothing is more common than unsuccessful men with talent. Genius will not. Unrewarded genius is almost a proverb. Education will not. The world is full of educated derelicts. Persistence and determination alone are omnipotent. And so the calls for more transparency, scrutiny and accountability in the family justice system, I think, are not going away. And because they're based both on people's real experiences of injustice, as well as the widespread and deep perception of injustice, my sense is that the more these calls are resisted, the more persistent and the more irresistible they are going to become. And that's me done.
Somewhere there's a clicking in the system. I don't know what that might be, but if anyone can find out what that is. Thank you, Louise. That's very succinct and powerfully presented. Right. So in terms of the status quo not being sustainable, I just spotted Nicola's hand up, but I'd started speaking. I'll carry on. The status quo, that includes what you described as the fiddling around the edges of the situation that we've got now. It would help me to understand what it is that you think should replace the status quo. How far should we go? Should the family court simply be as open as the criminal court is, or should there be some restrictions? Should reporters be allowed in but no one else? I hear loud and clear your message, but what is it you think that we ought to be doing to replace the status quo?
Well, I have wrestled with this, and although in lots of ways it would be really valuable for the family courts to be completely open, and of course the Court of Protection now sits in public. There is one High Court judge who I understand, and has told me himself, in fact, in the Pret, opposite the Royal Courts of Justice, always sits in public. And I said, care cases too? And he said, yes, care cases too. Mm-hmm. I think for the most part, that is going to be not helpful for the family justice system generally, given the particular nature of lots of what happens and also the vulnerabilities of the people in it. So as a journalist, I am always keen for complete openness, but I think there are really powerful factors against it in this case. So I think that journalists should, as they do in Ireland, and as they do, I think, in some parts of the family law system in Australia, should have the right to publish what they observe themselves in family courts without having to ask a judge for permission. I think they should be able to talk to anyone who wants to talk to them about their family law case without they or those parties or lawyers or local authorities fearing being in contempt. And I think that should be open to legal bloggers too. And although it probably is available to academics at the moment, I am unsure as to how easy it is for them to gain access to the courts, or what restrictions there are on them being able to describe what they see in them during the course of their research.
Right. So would the openness would come through the filter of reporting by a journalist, a legal blogger, academic.
Yes. I
And
mean,
they would, sorry, that they would be allowed in as they are now, but not restricted at all in what they report. So whatever they see that they could report.
I think that you would then be in a situation where a judge could impose restrictions as appropriate, subject to argument. But the basic principle would be that you can report anonymously, of course, and there needs to be some careful work, some careful thinking about how that anonymity is to be practiced. Obviously, there's a background to that because there's anonymity guidance, some of which I disagree with. But clearly, there would need to be the opportunity for restrictions to protect anonymity. But that's as far as I think it should go.
Yeah. Right, just I'll hand over to Nicola in just a moment. When you say in Ireland, journalists report, we heard from the Carol Coulter on the last occasion, and I understood her evidence to be that she and they're a team of young lawyers, I think, go in and watch, and then they produce a digest every 6 months of what they've seen. I don't know that the journalists go in.
Yeah. So I went to meet Carol a couple of years ago,
and seen your blog.
Yes, and I interviewed. I looked at the legislation there, and I interviewed the legal editor of the Irish Independent. So my understanding is that journalists have got the right to go not just into court, but to report what they see. They're subject to really quite strict, quite stringent sanctions if they report anything, which I think that the terminology is along the lines of which might tend to identify a party. And what the editor of the Irish Independent said to me was that was actually really quite chilling in itself, because the fines are huge. I think it's €50,000 or you can be banged up. So he said that it's actually rare that we go in and do that, but we do have the right to do it. Right. And I understand that it tends to only be kind of very well resourced TV and other broadcast organisations that occasionally go and make use of that right.
Yes, I think, that tunes with now what Carol said about the size of the fine and the potential prison sentence, which has sharpened the focus of the journalist.
Yeah.
Great. Nicola, I think you were first in the hands up queue.
Thank you. Yeah, it was very interesting and good follow-up questions from the President, so thank you. Louise, I'm being slow, so forgive me. I love the Calvin Coolidge quote, but I wasn't sure I understood what was different in point 4 from point 1.
Oh, I think I'm probably just underlining myself.
Good. That's very helpful to me. Thank you.
Okay. Claire.
Oh, I can't hear you.
No, you're muted, Claire.
Hang on. I'm unmuted.
You're unmuted.
Yes. Now, you can go into court and see things and report what you see, but if you don't see any of the background information, then you don't know what you're reporting on. You need to see the papers. You need to see skeleton arguments, etc.
Wouldn't that be great?
Yes. You could go in and be completely mystified after sitting there for 2 days, or not completely mystified, but you don't know everything you need to know to report it.
Yes, no, I mean, absolutely. One needs as much of the paperwork as the parties are willing to give you. I think that basic skeleton arguments, a case summary, and a case summary should be given to you. And I don't think for accredited journalists or legal bloggers or academics, if they were to have the same right as us to go in, I think we could be trusted not to publish that information, because it is really onerous to ask. And I know this from my own experience of having to anonymise things, court documents. It is really onerous to be asked to anonymise those documents. But I think, yeah, absolutely. For instance, I regularly ask for skeleton arguments and did so for an appeal court case last week. I got them at the very last minute, one kind of 10 o'clock at night, the night before. I was meant to be live tweeting that case the next day, and it is very difficult without those documents. You do need them to be able to make an informed comment. I mean, of course, the kind of journalism I do tends not to be straight court reporting. The kind of journalism I do is much more kind of investigative background, features type, long read investigations. And you need it for that as well, but you have more time. But it needs to be, all of that stuff needs to be available and as far in advance as possible, without the resistance that I constantly come up against, or people being very nervous actually of giving you those documents and having to apply to the court, and then the court being very busy and not having time to get to decide whether or not a journalist can have it until, as we saw last week, the last minute.
Can I help those of you who are not so familiar that going back 30 years, there weren't any skeleton arguments or summaries, and the journalist would sit in court and, like the judge, they'd hear the lawyer spout an account of what the case was all about, and they'd write it down and they'd report it. Now, in advance, parties put in their argument as a skeleton argument on paper, and often there's an opening summary which is submitted on paper to the judge, so that's taken as read. So the case proceeds, and with that taken as read, and the journalist coming in for the first time won't necessarily know what the case is about, and the lawyer will say, "Can I turn to paragraph 12 of my skeleton argument, my lord?" And the journalist hasn't got it. So in the Court of Appeal, it's the rule now that the journalists attend physically, when this is pre-COVID, and are given the skeleton arguments at court so they can follow it. Where we're scratching towards practicing COVID now is getting those out in advance in the Court of Appeal. But what you're saying is that it ought to be the norm that journalists are given that background information, and it's given to them not to be able to cut and paste and report skeleton arguments. It's given to them to help them understand what then unfolds during the oral court hearing. And
because if you don't understand the background, you can very easily misreport something.
Yes, or you waste intellectual time during the hearing wondering what on earth it's about, when you should be listening, or when you want to be listening to what's actually going on live in front of you. I
have had the odd judge ask the barristers to very quickly sum up what their case is about when I've turned up. That's been helpful. Well,
we heard from Celia Kitzinger, who, as you know, has been working with the Court of Protection, and she says because observers are now coming in on a regular basis to the Court of Protection, the custom has developed of the barrister giving a short opening summary to the court, so that the journalists and the public can hear it before the case starts. It's going back to what we did before, but for a different reason, and they're shorter summaries. So that would be perfectly possible. But my experience is that journalists, very, very much, with very few exceptions, take the skeleton arguments and don't publish them, but do use them as just as background material in the way I've described. Anthony.
Yes, thanks, Andrew, and thanks, Louise. My line of not so much questioning but discussion is about transparency for a purpose. So although transparency, as you say, is the direction of travel in wider society, then if something is brought to light as a result, it must be true that something is done about it.
One would hope
so. With everything else we do, we have either learning programs, action plans. Things change, but at least they should. So I guess my line is to look at, for the children and families themselves, and the issues that might be public interest issues that come up, what might the mechanism be for introducing the change that might be necessary? Because we've tended to talk mostly about the reporting, not the outcomes of the reporting.
I suppose I come at this from the perspective of the person who does the exposition of the problem, but the media is not there to provide the solution. So when there is, when there is an investigation into appalling practice in the NHS, the media's role in that is to investigate, to publicise, to give a platform to people who might have ideas for how to do the follow-up and how to do the work. But I couldn't put myself forward as the person who would say, I know what the mechanism would be afterwards.
Yes, okay, which is, I guess, then I just think it probably needs more of a structure and an infrastructure around it than we've got, which is that you would hope something comes back to the original agency or agencies to follow up, and sometimes advisors take an interest in it, sometimes government departments take an interest, and so on. But it's very hit and miss.
Well, I would agree. I mean, I'm thinking of an article I did a couple of years ago now about kinship care. And I did it for the Times magazine, and it was the first big feature I'd done for that magazine. And I was told later by the CEO of a kinship care charity that that the article had been waved around by the senior civil servant in that department to the minister, and because it was the Times, that they'd happened to read it over their Saturday breakfast, and that a big noise was then made about the kind of funding that kinship carers were getting, as opposed to the pittance that many of them do receive. So I agree it's hit and miss, but I don't think that it's really my role to create the structure afterwards. That would be for someone like you.
Yes, indeed. So I would guess then the answer is possibly, well, the more transparency, the more the likelihood of follow-up and action, because of shining a light on it, even if that isn't shining a light in a particular direction. But as you say,
Well,
people pick things up. But only don't forget your article I read, because it was in the Weekend Times magazine. If it's buried on page 43 of Wednesday's paper, it's not going to have as much life in it.
No, and believe me, the battles I have with editors to get space and prominence for articles. But it is going to be rare that a single article results in a defined outcome. Even with the biggest scandals that we are able to publicise over, think about the classic one, thalidomide, over many years, that takes huge effort to reverse all of the inertia, the corporate interests, the government resistance, the reputational risk. I'm not for a moment claiming that any of this is going to be a quick fix. Occasionally you might get something like the Winterbourne View panorama, but it's rare. It's going to be something that is in tiny increments over long periods of time.
Thank you.
So you're on mute.
Yeah, I am.
Yeah, thank you very much, Louise, for presenting so clearly a point of view. You mentioned the term radical change, and it would help me to understand, maybe in bullet points, what are the kind of, in headlines, what are the radical changes that are required from your point of view?
Well, the law needs to change because although I have proposed a pilot project within the existing law that still has to go through a lot of development, that is not radical change. That is a small-scale testing out. I think that there needs to be determined leadership from the top. That means Sir Andrew. And that would need to be sustained over a long period of time, because the culture within the family justice system, and in that I include CAFCAS and local authority children's services departments and legal departments, is to shut out scrutiny. Everybody pays lip service to it. It's never acceptable in that particular oh so sensitive case. And it's not just to do with applications, it's to do with the attitudes to me coming to court. It is relatively rare for me to turn up at a case either in person or remotely without there being a usually very badly grounded objection to me being there. And I'm then in the embarrassing position of having to put people right as to the grounds on which they can object to a journalist being there, the necessity that they have to base that objection on, and the fact that it's that they can't. So it is a reflexive problem within the system. And so I don't, when I say radical change, I mean that someone like Sir Andrew and his successors over, years, will need to absolutely require it of the whole system that openness and transparency is now the culture while retaining safeguards of anonymity. That's what I mean by radical. It can't just be a little bit of openness and a little bit of not and hedged around with this and that. It needs to be that is the approach.
So, for example, just to take your example of journalists turning up and feeling they're being questioned by judges as to why they're there and so on, for that to just fall away totally.
Why should any judge ask me why I have chosen this particular case, or which of has any party asked me to be there, and if so, which? That's really shocking. I have the right to be there. I don't need to answer that question, but how awkward to be in a situation to be asked it and simply to say, I'm here because I have a right to be here and I'm not going to answer your question, Judge, particularly when I may later be asking the judge for permission to be able to report on aspects of the case, including potentially their own behaviour.
And when it sort of extends to local authority and Kafka's, for example, which you mentioned, what do you see there? How should that, let's say, in practice be different?
They need to stop objecting to journalists being in court because they're worried for their own reputations.
I see. Okay, so it's a similar issue in a sense, that unquestioned access to the court and being present at hearings without being questioned by whether it's Kafka's or social services.
I mean, that should be the case already, because the grounds on which you're able to object to a journalist being there are very limited. And you have to provide evidence. I am regularly objected to being there, which, so there we go. And very few evidence, rather than assertion, is presented.
It shouldn't. I take the point. I understand the point about the need for leadership and a change of culture. But what's actually striking about the Court of Protection is that it went from being a effectively closed process to a totally open one in a very short time, and everybody, once the announcement that that's what was happening was made, everybody moved to accepting that. So I'm not as pessimistic about the amount of time the change could take. But what's interesting is that when I asked you earlier what you actually wanted to change, your proposals were relatively modest in terms of change of the law. Wasn't opening the court to everybody. It was journalists coming in as of right, and legal bloggers and academics. But what actually you want to see is a change of culture.
I don't think you can. If you had a change in the law straight away tomorrow, which I would love, but which isn't going to happen, I think it would be a massive shock to the system, to the family justice system. And I think it would, given that the change in the law, I believe, is going to come, wouldn't it be fantastic?
But the change in the law you propose is really very modest. That the journalists and legal bloggers can attend at the moment, and you want them to be able to report without having to ask permission of the court.
Well, it might be modest, but it's going to be.
But that's when you say there should be a change in the law. That's
in section 12. I think section 12 needs to be repealed.
Well,
as it relates to private family law hearings.
Yes, that wasn't the answer that you gave, and that's why. So you think section 12 should be repealed, and what difference would that therefore make?
Well, it would mean that the statute which bans me from being able to report on matters relating to proceedings falls away.
So at the moment, you're only entitled to report upon the gist of what goes on and the overall process.
I'm not really allowed to report on the overall process in any meaningful way. And the extensive litigation that has happened over 60 years to try and determine what matters relating to proceedings means just demonstrates that law is so poorly drafted that it's chilling. It's chilling to the media. The number of times I have had to argue with lawyers within the organisations I'm working with as to what I can report. Even on one occasion when I expressly told them the judge had given me oral permission in one case to report, and all of the detail was subsequently expunged from my report because people were too nervous.
Yeah, thank you. Natalie, you were next.
Yes, Louise, I don't come from a family justice background, and I come from a human rights background, and I totally get all the stuff about scrutiny and scrutiny of all the players, judges and so on. But I want to pick up on Claire's point and just try and think a bit about the practicalities, because I get to stage one and think this is all easy, and then I get stage one and it becomes very complicated. So think about childcare cases. We've heard a lot about the Court of Protection being open, and the Court of Appeal, you get skeletons. But the reality of those courts is very different from a first instance court doing a childcare case. So Court of Appeal doesn't usually grapple with evidence. It's unlikely to be looking at the detail of the background reports. Court of Protection, it's about one person who themselves doesn't have capacity, and it's relatively easy to anonymise. Childcare cases, the scenario I'm looking at is a parent comes to you and says, this is a total travesty, complete miscarriage of justice, it's all an outrage. And on the face of it, that may be right. But the truth may be buried in a lot of very detailed, incredibly sensitive reports that may well and often will impact on third parties as well, and impact really, really intrusively on third parties. Yeah. Now, if you don't have, this is where Claire's point comes in. If you don't have all that, it's easy enough for the barrister to give a 5-minute potted. This is a case about little Johnny being taken away from his parents because of sexual abuse by the father. Yeah. Easy to give the potted summary. Doesn't begin to say what's going on in the background. And if you only get the dad or the mum's report, you get a totally skewed thing. But if you start getting the background papers, then that opens up all sorts of really complicated cans of worms, which include third parties who would be, even with any level of anonymisation, you know, I've got one of these cases at the moment, they just don't want the intimate details of their sexual life told to journalists in any circumstances. And although I can see that there's some bigger point about democracy, if I'm a child who's not even subject to the proceedings, and I'm told that the journalists are going to get this information, I'm going to be massively unhappy about that. And I find that really quite a difficult circle to square, to ensure the journalist has enough information to be able to give properly informed, balanced and accurate report without pushing a coach and horses through some really sensitive material. And I don't know where you see that balance being, because it doesn't seem to me it is an easy balance. And maybe it's always going to be a fact-specific balance, but it's not. I just want your thoughts on that.
It's not an easy balance. I have never made any bones of the fact that by going for what I want, there are times in which the most vulnerable people in a particular case will be required, in fact, to shoulder somewhat more risk. Never shirked away from that. In criminal courts, many of those extremely sensitive, very difficult and painful facts are brought to light and are fully capable of being reported. And we believe in our system that that should be the case, because in those cases, if somebody is risking their liberty, even if they may end up being a very unpleasant person, we believe that it is more important that there is open justice to keep the system safe than it is to protect some of the most vulnerable people in society. So I don't pretend that it is easy, and I don't pretend it is risk-free. I think there are going to be ways of, because a judge is always going to be able to restrict certain information, there are some safeguards. That happens in criminal cases too. The media is not regularly or even occasionally charged with making public details that they should not, or identifying people they should not. I appreciate that that is the mainstream media, and I appreciate that extremely exceptionally mistakes happen One did happen, and it was the BBC, and a rape victim's name was broadcast because they had forgotten which was the pseudonym. That was really terrible, and they were prosecuted. I think there will need to be some trial and error, and I don't pretend there won't be some error. But I think that the system as it stands at the moment, I think it will be safer for all children to have a system, A, that is trusted better by those who are brought before it, and who are subject to the great powers that it wields. And I think that children will benefit more broadly by the fact that the system will know it is being scrutinised, and that some of the processes that I have read of in transcripts that I most certainly should not have been given, and the things that I have seen in some cases that certainly should not have happened, would be able to be brought to light. And again, as I said earlier, I don't think this is a quick fix. It's not a short thing. Even the criminal justice system, which is, capable of being reported openly, is very far from perfect. But I think it would be better than what happens now, where mistakes are swept under the carpet, where local authorities, plead desperately with judges not to be identified when they have done things which the judge has very seriously criticised them for. And I was in a case like this in front of Mr. Justice Hayden recently, where the local authority then spent a further £6,200, which I had to secure from them with a freedom of information request, to argue against my application to be able to report what they had done, and which I subsequently succeeded in. So yeah, it's difficult, and we will have to work hard at it.
Thank you.
Yes, Anthony.
Yes, at the risk of going back earlier in the discussion, it's just a point about Louise. I've agreed with almost everything you said, apart from the point about, certainly in my work in Kafkas, that it was protecting reputations. I can't quite remember the number of hours, but hundreds spent on cases like Charlie Gard, trying to work out on reporting applications what was in the child's best interests. I don't remember in those hundreds of hours ever a defensive discussion about, well, what's the implication for us, or what if we're named? Honestly, I mean, it never ever occurred, and I don't want to sound holier than thou, but it's almost a point of just fact. I think it might be different in some local authorities. In fact, I know it is, but not all. The majority of the discussions that we have are about trying to look at the impact on the child and the consequences, because that was our role. So go on.
Well, there are two things I say to that. Well, one is, it's really reassuring. The second is, did you ever also consider the wider benefit to children in general of allowing journalists to report, rather than just the impact on that particular child? You may not have seen that as your role, but I think for all public bodies.
Much.
So okay, well, that's good too. And I guess the second point I would make is that I have had in an application that I have made to be able to report something, the written skeleton argument came back from the local authority, specifically saying that their reputation was at risk, and it was going to be difficult for them to recruit social workers if this was publicised. It was only one of the legs of their argument, but it was absolutely blatant, and the judge completely took it down. So, that, I'm afraid, that reputation is a factor, and it's not the first time that's been argued.
Yes, sometimes.
Yeah.
Okay.
Yeah.
Thank you.
Can I ask a different matter, Louise? Part of the current status quo is that judges are encouraged to put their judgments up on Bailey, in anonymised form. The data shows that that's fallen off in terms of the number of judgments, but assume that a fair number are being put up. Is that useful? Does that serve a purpose?
It's very useful.
It's very useful.
It serves a purpose. It doesn't serve the whole purpose, because you are then seeing the judge's perspective, which is only one perspective. And what if the judge is the problem?
But it's useful in the sense that, I'm assuming that journalists come and sit in, and it's either a targeted thing, a parent has got in touch with, or someone's got or it's a haphazard thing. But through the publication on Bailey, you're learning about cases you wouldn't otherwise.
Oh yeah, absolutely. No. I mean, I think that is really useful.
It's useful. We're likely to hear evidence that young people are astonished by the degree of graphic detail that these judgments, although they're anonymous, contain. And the last thing that they would think they would want if it was about them is for that to be out on the internet for everyone to see for all times. Is there merit in the thought that if more judgments are going to be published, if we're having a change of culture, I encourage judges to put judgments on Bailey, that they shouldn't contain that level of detail, that the judgments that go out should be structurally describing what went on, but have the detail of the evidence of sexual abuse, for example, taken out and be available to the parties, but not put out there on the web?
I mean, I have heard Peter Jackson in a panel discussion take great exception to the idea that he should be limited in what he is able to describe in his judgments, because he feels it is very important that the full import of what has happened to children is understood by society.
Right.
And I understand that point of view. I think it should be up to the judge, actually.
Right.
I do. I think it should be up to the individual judge. I don't love reading through judgments with lots of graphic detail.
No.
Much more worryingly is the idea that they might be searched for by people who take pleasure in it. It is important in a society which has denied for many decades the impact of what happens to children when they are sexually abused, to fully understand what some children are enduring and are put through. So I don't think that's, in an article, I would be very selective in what I would choose to describe, and have been very selective for years in what I describe about what people tell me. And I'm not talking about family court cases here. I'm talking about all sorts of stuff to do with domestic abuse and child sexual abuse, which I reported on for a bit around what happened in schools. No, I think there are times when it matters to know.
No, that's a very helpful, thoughtful answer. Thank you. Nicola.
This is a slightly different angle. We've heard from quite a lot of people that it's difficult to find a case or to track a case. And so I was just wondering whether you think, you've mentioned the criminal justice system, and I wonder whether it's much easier than there, and there is something we can learn from.
Do you know what? I don't know. I've never reported on criminal cases. I do know that the listing system is an absolute maze. It is impenetrable to anybody who is not deeply versed in the way that the family justice system operates. Kind of a scramble of letters and numbers and dates. One has no clue what's going on. I mean, literally. The person who understands best is Brian Farmer, who is the PA's kind of stalwart reporter on family courts and the Court of Protection. He gets it. I don't. And listings would be such an easy win. It's one of the proposals I've made in my family court reporting pilot proposal as to how cases could be described in the listing system, just for an easy grasp of what type of case it was and at what stage it was at. I don't think it would take a lot. Take something. It wouldn't take a lot.
Have we had that document?
Yes.
Yes,
but only last week in my second set of evidence.
Right, good. Well, I'll make sure I've seen that. I think I have. In the criminal court, it's only one stage better. You could turn up at the criminal court in Wolverhampton or wherever, and you just see a list of names.
Right.
And it doesn't say grievous bodily harm or drunk driving or whatever. But in the family court, there aren't even the names, as Louise says. It's the case number, which is a computer code type thing, and with a date inside it, and an initial probably.
And it's done differently in different court centres as well. You go to different places and there's a different formula. It would be very useful to have something that simply told you whether it was just a private law or public law case. In fact, you can glean that if you know, but it's not simple. And it would be really useful to know if it was, an application for a non-molestation order, or if it was an application to remove a child into care, or if it was an application to any detail more than a few scrambled letters and numbers would be a great positive.
Yeah, and as you say, that would be an easy, well, but it is low-hanging fruit. It's something that we've got control over. Yeah.
Yes.
It's part of your culture change, as how I describe. Is that right? It's one of the things that you think would come with a change in culture.
Yeah. What is going on in the court?
If there was a change of culture, it would be something you'd want to do.
Yes.
You would want to have at the front window, as it were, a list of what's going on. Now we've got beyond the time allotted to you, so it just shows the richness of what you have to say. Does anyone have any further questions? And Louise, is there anything that you would like to say to us that you haven't managed to produce as one of the answers to the questions, or in your opening remarks?
I think that the thing I'd like to finish off with is that I do see good practice when I come to courts. I see excellent people. I see people who are, so expert in what they do. And there are times when I would like to be able to talk about that as well. I have an application to be able to report one family judge's judgment on coercive control, because I think it's fantastic. There are big difficulties in whether that will ever be able to be published because of who it concerns. But one of the reasons I want to publish it is because I think it gives an example of what is happening in a lower court. It's a circuit judge. It's not a high court judge. It's not an appeal judge, about something that is of high public interest right now. The domestic abuse bill is going through. There is huge concern about how the family justice system understands coercive control. And here is a judgment which shows a very clear and full description of how a judge has come to her findings. That is valuable too.
No, I think it's obviously a complicated picture, but part of it is, certainly I feel, that the family justice system does not have anything to hide, and it is being criticised for being the secret family justice system on the basis that it is trying to hide all sorts of practices which the public would be astonished about. Well, that's not my perspective, but you're entitled to say, or the public are entitled to say, how do we know?
Yes.
I actually found that clarification is really helpful, Louise, because I think, under the impression that you thought everything was very dangerous and there were awful things going on in all sorts of places. And so it was really helpful to hear that actually you think there's some really great practice as well. So
there is. I get a lot of help from people who are really committed to helping me understand. And, I don't go to court every day. One can't afford to do that. But I dip in and out, particularly during the pandemic, because it's much easier now because of remote hearings to do that and not to have to travel. And I see good stuff and I see bad stuff.
Yeah. Thank you.
Thank you.
We're all going to depart and meet in another virtual room.
Yes.
But Louise, thank you very much for your time.
No, well, thank you so much for having me.
For stepping up to the plate at very short notice.
That's all right. Thank you.
Thanks, Louise.
Thank you.
Thank you. Lovely to see you all.
Bye.